The Michigan Probate Administration timeline. Hi, I'm Darren Findling of the Probate Pro, and we're going to walk you through the timeline that exists to commence and administer a probate estate in Michigan. Really important note here. Every single probate estate is unique. So I'm giving a general timeline for information purposes so you have a sense of how a probate estate generally flows. There are different types of probate estates. There are full probate estate administration and there are small estate administrations. So I'm speaking here specifically about a full probate administration that occurs through the probate process. And I strongly urge you to work with a skilled, competent probate lawyer as you navigate through this process, because you'll see it's not always intuitive. The beginning of your probate estate is really an important step. You have to decide whether you're going to do it by petition, a formal probate process, or by application, an informal probate process. Both of those require very careful consideration. Is everyone harmonious and getting along and collaborating, or are there problems and those don't exist? And there's complexities that would require an adjudication of your petition in front of a judge. Informal occurs through the court register, formal occurs through a judge. So there's going to be an adjudication on the opening of the estate, the appointment of a personal representative, the admission of a will, and the identification of the heirs and or devisees. Important consideration right at the beginning. The next major thing that occurs is generally you're publishing in the legal news for creditors. There's two basic concepts around creditors. There is known creditors. This requires the personal representative to give notice to those creditors that they know of or they reasonably should have known. And there's a particular statute that governs that entire creditor process. And then there are the unknown creditors, creditors you may not know of, the neighbor down the street, the visa company, or maybe the medical provider. These are unknown creditors, and publication serves to give notice to the unknown creditors. So known creditors get direct notice, unknown creditors get notice by publication. You can see that is a 4-month process, and there's a particular statute or set of statutes that govern the entire claim process for creditors. The next step is the issuance of letters of authority. Letters of authority are really the golden ticket. This is what you're trying to obtain through the court system so that you have the legal authority to administer the estate. The letters of authority are like the keys, the golden ticket. It's the opportunity to access the bank accounts, the apartment building, to sell the house, to liquidate assets, to do everything that you could possibly do under the statute are issued through the letters of authority. There may be restrictions on those letters of authority, but that is the golden ticket to move forward with the administration. The next basic step is there's a whole bunch of noticing that goes on. Notice to the heirs, notice of duties, notice regarding attorney fees, notice to the friend of the court, lots of noticing requirements, as well as the notice to the known creditors that I just referenced. Next major step, and again, you can see there's spaces here, but I'm not giving specific timelines because some of them are happening all at the exact same time and some of them are staged, is you're gathering and identifying the assets that the person may own. Now remember, there are some assets that are identified through probate, and there are some assets that are not part of probate. So for example, assets that are not part of probate would have a named beneficiary. Think of a life insurance policy with a named beneficiary. Or maybe there's a joint asset with survivorship rights. Two people own a house as joint tenants, and upon the death of this person, maybe the survivor takes. So when we're talking about probate assets, we're talking about assets that are only in the decedent's estate with no named beneficiary and no joint owner. So what we typically tell people to do is really get a sense of each asset, identify the name of the asset, how it's titled, how it's owned, how it's titled, to see if there's any identification of joint owners or pan-death beneficiaries. And then lastly, its approximate valuation and whether there's any liens, any debt attached to that particular asset. So you're identifying and gathering the assets of the decedent. And then, of course, there's a requirement to either present or file an inventory with the probate court. An inventory is really just a snapshot of what the decedent owned that is probatable for purposes of administering the estate. as of the date of death. So these aren't things that have been received during the administration, but it's a snapshot as of the date of death. There's a whole body of statutes that govern how an inventory is prepared, what information must be contained on it, what supporting documentation must be provided for. But that inventory is an important step. You have a right to either present the inventory to the probate court if there's no supervision, or file the inventory with the probate court. And the court then assesses a gross inventory fee based on the value as reflected on the inventory. That decision about presenting and or filing is also an important consideration as to whether you want that information to be made public as part of the larger public file at the probate court. The next major step is you're administering the estate assets. And this is just a broad term. It could mean that you're selling the house. Maybe you're liquidating a bank account. Maybe you're selling a motorcycle. You're cleaning out the house. Administering the assets is doing all of those major steps as personal representative to take care of the affairs of the decedent. The next major step is resolving the debt. Now you can see it coincides with the expiration of the creditor period, because usually you start resolving and addressing the debt in totality at the conclusion of the creditor period when no more creditors can come forward. Now those creditors could be secured creditors, they could be tax, IRS obligations, they could be unsecured creditors like medical bills, all different types of creditors. And you have to follow the prioritization statute as well as the creditor claim statutes to make sure that the creditors have followed the requisite statutory obligations, and then you have to resolve them. I use the word resolve and not pay because you may not be paying the creditors. You may not need to pay the creditors. There are certain exemptions and allowances that come before creditors, or maybe the creditors haven't followed the statutory obligations of which the personal representative would be required to pay. Again, a very important consideration. There's a lot of nuance here, and people who understand the probate process know how to navigate through this by following the statutes and case law that relates to resolving estate debt. Then, of course, you're distributing at some point. After you've addressed all this, you're going to start distributing pursuant to the will. We call that testate, or under the intestate statutes if there are no wills. The intestate statutes are statutes that are determining who gets what based on their relationship in the event that no will exists. Another very important step, because you have to make sure that you are distributing correctly to the right people, because it's very hard to discourse to get that money back after it's been distributed. And then eventually you close the estate. And in most cases in Michigan, there's a requirement that the probate file, the estate, remain open for a minimum of 5 months. And again, giving you a broad paintbrush stroke of the Michigan probate administration process. A broad stroke because there's so many little details that are not contained within this explanation. Details that are not intuitive, details that require you to have a clear understanding of the Michigan court rules and Michigan statutes, and of course the case law that is surrounding the Michigan related probate issues. So again, a broad paintbrush stroke understanding of the basic timeline that exists in a probate administration. If you've got questions about probate related issues, you are welcome to call the Probate Pro at 833-PROBATE or visit us at theprobatepro.com. We have a wealth of information on YouTube as well as on our website, including forms. We wish you the best as you navigate through the probate process.